Well, good morning, everybody. That's just gone 10 a.m. on Thursday, 15th of January 2026. Welcome to session 3 of this public inquiry into the application by Fred Olsen Renewables Limited for the proposed Lees Hill Renewable Energy Park at Lees Hill near Duns. I think we all know each other by now, but I'll just remind everybody I'm Nick Smith. I'm a reporter working for Scottish Government's Planning and Environmental Appeals Division, also known as DPEA, and I've been appointed by Scottish ministers to prepare a report and recommendations for them about whether the proposed Lees Hill Renewable Energy Park should or should not be granted consent under Section 36 of the Electricity Act 1989 and deemed planning permission under Section 57 of the Town and Country Planning Scotland Act 1997. As in previous days, before we get underway, there's some notices and some housekeeping matters that I need to deal with. So as with each day, I need to read the brief. We are broadcasting live on the internet. The sound recordings will be stored as part of, and visual recordings will be stored as part of the DPA's webcast archive and will be capable of repeated viewing. By participating in these virtual sessions, participants are consenting to being filmed and to the use and storage of those images and sound recordings and any information pertaining to them, containing those for webcasting and training purposes and for the purpose of keeping historical records and making those records available to the public. Further details can be found on the DPA privacy notice on the relevant part of the gov.scot website. And as with earlier in the week, colleagues from DPA, David and Connor, are looking after us on that side of things for today. I mentioned yesterday and I'll mention again today, the mics, if you're moving them, please move them by the base. The tops will move, but please don't pick them up by the stem, or you will incur the displeasure of David and Connor for doing that, so please be mindful of that. Social media and photographs, for data protection and privacy reasons, request that participants do not take any photographs or other recordings of their own during the sessions unless those being photographed or recorded have consented to this. I do not. Today's session, well, we have two sessions today. Originally this was programmed for Friday, so if you're watching here or tuning in at home, and expecting to see landscape and visual. This was always the overrun day in the possibility that we needed it. We got through everything yesterday and the parties agreed earlier in the week that they thought that would be the case, and so we brought forward both policy and the draft conditions hearing sessions from Friday to today. And if we complete those today, which I think we're optimistic about, then that will be the point at which I close the public inquiry and we won't sit tomorrow, Friday. Depending on progress this morning, I'll look to take a mid-morning break about 11ish, probably more like 11:30, depending on where we are, and we'll break for lunch about 1. Can you still hear me? There we go. Sorry, I lost sound for a moment there. Once I formally close the public inquiry, participants will have an opportunity to submit closing statements and summaries of case in writing. We'll talk about the timings for those at the end. We agreed time extension yesterday, and I'll just remind parties of that when we get to the end of proceedings today. The public bit of this public inquiry means that you get to watch what happens and you can listen to the discussion, but it's not a public meeting where you get to come say your piece. Documents are electronic. The applicant has kindly placed laptops at the back of the room, so if those watching want to look up documents on those, they can. The visualisations and mapping data is still out on the table. We've used those over the last couple of days. I suspect the likelihood of using them today is more limited, but they're there in any case if needed. I did my site inspection in September 2025 and earlier this week, so I think parties are aware of that from previous days. No fire alarm is expected today, so if it goes off, it's real. Please leave the building, and the emergency rally point is just around the corner at number 6A in the square. There should be a fire register just here, which I should have passed around earlier. If you can chuck your names and dates on that. We've had lots of people, so we've gone through all the fancy forms, so it's just a piece of paper today, I'm afraid. Toilet and kitchens just through the double doors. Please be aware there is a wheelchair ramp just there on the left behind that door, so please just be aware of that if you're going through. There's a lot of equipment and cabling around, so as always, just please make yourself aware of where that is. Documents, coats, bags and what have you, if you can just please make sure they're stored so there's no additional trip hazards. The There is a cable just behind Mr. Campbell and Mr. Whitfield with a cable tidy, but the tidy itself has got a raised profile, so if you're walking around, just be aware of that. And that just brings me on to then courtesy and behaviour. I've gone through these on days each time, but I'll remind parties that all participants and everyone who's observing, you'll no doubt hear people say things that you don't agree with, but please be polite and respectful. Please give other parties the time and courtesy they need to express their views, give their evidence and answer the questions in the same way that you would expect this to be done for you. I need to hear what each party's got to say. The principles of courtesy and respect for other participants extend beyond the confines of this room and also request that those principles are followed by those taking part today, particularly people who are wishing to comment on proceedings via social media. And as mentioned earlier, photographs or recordings other than the DPA webcast should not be made or published unless those featured have consented to this. And again, I don't. Do we have any members of the press with us? No? Okay. I'm not aware of any weather warnings for today. Are people content with the temperature in the room? I think we've gone through various temperatures in the room this week, so hopefully we'll not be getting too warm. As ever, please don't leave valuables in the building. And just keep those with you. Okay, that moves us on to the introduction of parties. So I'll invite the applicant first, and then we'll go to the council and then Mr. Campbell.
Thanks, sir. Good morning. My name is Marcus Trinick, Solicitor of King's Counsel, instructed by Amy Howard, who sits to my left, of Wright Johnson Mackenzie. My witness in this session, who will do all the talking, is David Bell, of David Bell Planning, sits to my left. And to Amy Howard's left, is Emily Galloway,
Advocate and King's Counsel. I'm part of and represent Dunsleys Hill SRS, and I'm also labelled as a witness today. Mr. Whitfield is with me, the owner and resident of Old Langton Leys.
And will it just be you speaking, or are both of you speaking today?
Probably Mr. Whitfield more than me.
Okay, thank you everybody for that. And I'll just check if there are any updates for me this morning. I received the email that I think was circulated to those participating in the hearing session, which was, I think, promised yesterday, and that was, I think, an update on the position of the council and the applicant with regard to those things. I think we'll probably deal with those as we go through that agenda, unless there's anything particularly you want to address with me just now. That's fine, we'll pick that up at that point, but I've got that anyway, I've seen that. Are there any other updates for me this morning?
One update on the noise conditions. I think we are drifting closer together, but I haven't had time to look through the revised noise condition. I'd rather deal with closing submissions as anticipated. I'll let Mr. Campbell address you on the question of the accuracy of the visuals. That's been progressed, but I'll let you do that. My only question is, do you anticipate further site visits?
At present, no, but I think, are you asking in terms of arranging accompanied site inspections, yes, or just in general? I don't anticipate that at the moment. However, it might be, I can't yet foresee when I start writing, having considered everything that I've heard over recent days. If I need to do that, I will be in contact with parties to arrange that. But at the moment, I have been to pretty much everywhere, I think, and I've been to, obviously we were discussing matters yesterday with regard to Mr. Whitfield's property, and I have been on site at that property. No. Okay. Any further update and comment on those?
No, nothing further from the council at this point.
Only the question of the documents which have been withdrawn. I've sent Ms. Howard an email and on the second attempt, I think I've got it right, with the numbers of 5 documents which I wish to withdraw. When she tells me that she's content with those numbers, then I will send it to Christine Brown.
Confirm that's now agreed. Thank you.
Sorry? You can.
Here, it's
yeah.
never good, Jace.
And so you can send that to the case officer, and then I'll get that in due. Oh, excuse me. And then I'll get that in due course. Okay, so that's to do with those.
I should say I'm much obliged to Miss Dower for her assistance with that.
That's kind of you to acknowledge. Any other updates or points for me before we begin?
No, I don't think so. Sorry, no.
Nothing further.
Nothing. No, nothing further. Thank you.
Thank you all. Okay, that brings us on. Oh, sorry, go on.
Perhaps to assure you, if you want to make another visit to Old Langton Leys or the track leading to it, then we can assure you of our cooperation in that respect.
That's kind, and
If you need cooperation.
thank you. No, as I mentioned earlier, if I feel further need to do that, then I'll make parties aware, and I'll be in contact with all of you to A, make the arrangements, and B, show you that that's what I'm doing. So yeah, rest assured on that. Okay. So let's proceed then, if there's nothing further, on to the agenda for the policy 2016, listed as the final item along with others in that block. This is on the basis that NPF4 now contains the relevant policy, and that the age of much of the guidance, including the advice that has been mentioned there, has prompted its withdrawal. So the first thing, and we'll take A and B together, the first thing is, do the parties agree that this is so? So am I correct in my assumption and my reading of that? So you can tell me if that's right or wrong. And if not, what status does that draft? I've written guidance here, but I should have written advice, because of course the title of the document involves advice. So what's if my assumptions here are incorrect, what status does that draft guidance hold? Mr. Campbell.
Therefore, I can refer to that in my closing submission and make the appropriate alteration to my hearing statement. If NPF4 is the only place we find guidance, then that's where we have to look.
So having had the opportunity to look at the blog of the Scottish Government, you're in agreement with my understanding of that is what has happened?
Yes, Mr. Whitfield's got a contribution to make too, I think.
Yes, Mr. Whitfield.
Just to preface my remarks with my experience, I'm a retired finance director with a degree in economics, just to put that sort of on the table. My perception of those draft guidance was that it was just good principles, and those principles hold for any sort of investment of this kind. I've been looking overnight for other examples, and there's a Scottish Public Finance Manual with an appraisal and evaluation checklist to have here. I appreciate that hasn't been put into documents, and it has broadly the same principles as I would expect from an investment of such a nature.
What did it win?
So do I understand you properly that although you agree that that particular document is withdrawn, the principles that it outlines are, I don't want to put any words in your mouth, are good practice that would be expected either way?
Correct.
Okay, I understand. Did either of you want to say any more before I invite the others to come in?
No.
Did the council want to say anything about that?
I just agree with Part A that we agree with that statement you've made.
Mr. Trent, Mr. Bell, did you want to respond?
Thanks. So yes, agree with the position you've set out. So it's withdrawn, and therefore your second question doesn't apply. Really, there's no status to it. Thank you.
Okay, thank you all. So that then moves us on to the second part, unless there was nothing further on that. No, parties are happy. Right, okay. So that moves us on to the second part of this. So what does maximise net economic benefit mean in the context of LDP policy ED9, Renewable Energy Development, and MPF4 policy 11, Energy Part C, accepting that both policies contain the same provision? And I should say you're welcome to tell me in your response whether you don't think that's accurate. So we'll do each of these in turn. So if you can confuse people. If you can first of all address the point of maximise net economic benefit, what does that mean? And you're welcome to integrate into that Part C, which asks about, is there any territorial or scale requirement or limit implied by this? So I'll come back to Mr. Campbell first, and then we'll go to the council and then to the applicant.
I think a key point of this particular policy is that it is the net economic impact, and that there is no evidence that I can see that this has been considered by bigger economics. There is clearly economic activity on the site already. As described by Mr. Bell, it is mixed agricultural use currently, and I can't see anywhere in this document or any other documents I've looked at by bigger economics or Scottish Renewables that refers to the activity on the site currently. So my first point is that it's the net economic benefit, and I can't see any reference to the net element. I have other points, but I think that's key at this particular stage.
Would you explain what?
Sorry, so just to satisfy the policy, as described in both the draft guidance and in the other report that I discussed there, clearly there is a do nothing option. There's an opportunity cost to any investment. I have personally been involved in private sector bidding for public contracts. This is effectively a private sector bidding to provide a public service. And you always look at what the do nothing option is and what the net effect is of your proposal against what's currently happening on the site in this particular instance.
And so is your contention that your opinion seemed to be that there is an existing use of the land, and am I right then that you're saying the applicant's evidence does not consider, I'll use the word displacement, you can give me a different word if you want, but as I understood, the displacement effect of what that land is currently used for doesn't appear to have been considered, and therefore how can this be a net outcome, if you like? Correct.
If you look at all the documents that I've looked at in this regard from bigger economics, it talks about potentially as a downside on tourism, for example, and that is taken into consideration in work they've done here and elsewhere, but not in any of the work that I've looked at in this regard does it actually talk about what's happening on the site today. And clearly it's mixed agricultural use now. Potentially that will be reduced when there's solar panels all over the site and there's turbines going on there, and certainly it can't be used in a similar nature while the development is actually being built. Under those circumstances, clearly there won't be room to do that. So I don't know what the effect is, because we've asked bigger economics for a copy of their model. They've refused to give us their model to have it peer reviewed. I can't see any evidence anywhere that the work the bigger economics have done, either for this exercise or for the wider industry, that it's ever been peer reviewed. As I say, we attempted to do that, and we were declined the model.
And I suppose it obliges me to ask, and you may or may not know the answer. Is it fair for, if I follow through your arguments, and for those to hold good, would I have to come to a conclusion that there was actually some displacement of activity on the existing farm, and therefore would I need some knowledge of, for instance, you mentioned there that it was mixed livestock and arable, I think you'd said. So would I need to know whether the land, would I need to know whether the land upon which the proposed development was to stand was first of all used for arable at all, and if it is, then the effects of that, and if it's solely used for grazing, then how is that accommodated by that particular business? Are they things that I would need to understand?
think my point is we don't have the evidence that it is being considered. So you can't make that judgment, I can't make that judgment. And if you look at all the variables that have been looked at by bigger economics in any of their circumstances, there is no reference to the current activity on the site. We made a fairly outrageous comment in our submission that if this had been involved in knocking down a factory that employed hundreds of people, that is not taken into account the way I've read what bigger economics do. And that's it, you know, that's the extreme out here. Clearly, it's a small agricultural activity, but there is some economic activity on the site that can't be denied. What the value of that is, I've no idea.
And would I also, kind of thinking through that, then presumably there is a financial benefit to the current operator or user of the land from the proposal, and again, would I need to understand that? Perhaps I'm just trying to think through, might there be some sort of, even if the displacement that you're alluding to that you said we can't quantify, could that be made up for by financial gain that might occur from the proposal happening? Is there something there that I would need to understand?
So the economic benefit is quoted here in GVA. So as a very simple example, there are people employed currently on the site. We do not know whether the number would be the same post the development as pre the development. It may be that it is, it may be that it isn't, we don't know.
Yes, the emphasis is on net.
Yeah, as John said, the emphasis is on the net, and we do not know whether the net is being taken into account. And I can see no evidence that that has been taken into consideration. And as I say, I've looked quite hard at other Scottish Renewables. Bigger Economics have done a piece of work for Scottish Renewables, which I think we submitted as a document, a number of which I'll give you in a minute.
Yes, that's okay. Just find the document when you're ready. Let me know what it is.
Document 014-014.
014.014. Okay. Yep.
Which is entitled Maximising the Net Socio-Economic Benefit of Renewable Energy Guidance and Reporting Framework. This was written by Bigger Economics for the industry. Have you found it?
Just give me a second. Yeah. I will try and locate that.
See what date's on it.
It's recent. It's March, I think, this year. It's recent. I haven't got the date. This is a June 25 document. Sorry, it was June 25 document. Scottish Renewables published a press release.
Sorry, just give me a moment. It's not where I thought it was.
Don't worry.
Can I ask what paragraph we're looking at, please?
If we look at At the top of page 3, suggested content, if we've all found the...
Do you want to proceed? Because I'm having trouble finding it in my system, but you can tell me what it is and I can turn it up later.
So my point is that the press release that goes with this says maximising socio-economic benefits. It doesn't use the word net, and I can find nowhere in this document that suggests that the activity on the site should be considered. It talks about maximising the benefits of a project, and the only time it uses the word net is when it's quoting from NPF 4. And everything talks about maximising the benefit from a project, not the net benefit to the economy, which is what this is trying to identify as per NPF 4.
So your point is this is doing something slightly different to what?
This is maximising the benefits of the project, assuming the project is going to happen without taking into account what is currently happening on that site, which may or may not be negligible. We don't know.
It may continue alongside, it may not.
Yeah, it may continue on the site or it may not. And there are no, we're sort of moving on to other areas, but as per those good principles we talked about earlier, there is no sensitivity analysis that comes with this work. Because there's no peer review, there is no downside to the applicant, because it's never going to be looked at again. There's never going to be any post-appraisal, post-investment review of this. And the applicant continues to talk about these are conservative estimates. But there is no evidence that these are conservative assumptions, and there's no sensitivity analysis, all of which you would expect in a normal investment appraisal. I can assure you Fred Olsen would have done those for themselves on their internal appraisals, because that's what you do when you're doing a significant investment. But when we're looking at this from the economy's perspective, effectively what we're being told is, trust us.
Okay.
That's point 3.
Thank you. There were other points did you want to make?
I think I'll pause there.
Fair enough. Okay. So what I'll do is I'll invite the council to speak, and then we'll go to the applicant. So you'd say, are you intending making more remarks on that premise and Part C? Okay. So we can proceed on that basis. So, Mr. Wise, did you want to say anything?
Yeah, I think in general, what maximise net economic benefit means is unclear, as there's no plan in policy or guidance from the Scottish Government on this, and whether the benefits can be maximised. Saying this, as a council, we accept that the EIA findings are that there will be temporary negligible positive effects on the local and national economy, and we consider that there will be a positive net socio-economic benefit in planning terms against this policy in Part C. In terms of Part C on your agenda, as in whether there's a limit, there isn't a limit other than it being within the national territory of Scotland, as NPF 4 applies to Scotland. And whilst it does refer in the policy to local and community benefits, these are not exclusive. And this could be in the national scale as well. That's all I have to say.
So you said to me just there, I think, certainly on a territorial scale matter, you referenced local and community, which I think you were saying were covered there. But you also said to me that it applies to Scotland because NPF4 covers Scotland. So did you mean that the economic benefit, the maximising of net economic benefit in the context of reading NPF4 must mean that it only applies within Scotland, and therefore contributing factors to net economic benefit that are elsewhere, so elsewhere perhaps within the United Kingdom or outside of that sovereign nation state, would they not be, should they be excluded from consideration under that policy?
No, I don't think they should be excluded. I'm just using it on the basis that, this planning document is for Scotland, so yeah.
So it would apply to development within Scotland
Yeah.
Right,
But
but
it's-
the,
yeah.
the economic benefits
It could
that it's
go
asking
beyond,
to
yeah.
consider, I'm asking, is there a territorial limit within which it applies, or is it saying we can only count all these benefits must be within Scotland, or is it saying we can only count the ones that are in Scotland, or is it saying it applies to development within Scotland, but the economic benefits are not territorially locked, in your opinion?
No, they're not territorially locked.
Did you want to say any more?
I understand we were talking about the general question in C, but I can go on to D and E.
No, that's right. We'll focus on. I appreciate we'll kind of find ourselves drifting into bits there, but no, if we can focus on those just now. Okay. I'll let you come back before, and then the applicant can hear that before they respond.
My point would be that the answer to your question is the custom and practice that the wind industry has given the Scottish Government because it's never been checked. And they tend to give the answer as local economic benefits and Scottish benefits. Your point is well made. Are there UK benefits to this? I don't know. And again, we've ended up with a situation where bigger economics and the wind industry have given answers to this question to the Scottish economy and to the local economy without necessarily considering, I don't know, because again, we've not seen the evidence, anything wider than Scotland.
And yes, to clarify, it was a question rather than a point that I was making, but my question really with the territorial scale was about whether the maximisation of net economic benefits was territorially locked to Scotland in the sense that the benefits must be demonstrated within that within the boundaries of that territory, or whether it was something else. I think you may have answered it, but I'm happy for you to.
I think there is an assumption. I'm sort of paraphrasing what I read from what's been presented, that, for example, in this case, which is the project that is close to the border, the comments that are in the documents say there could be a benefit from contracts for the local economy and for Scotland. There could be benefits for contractors in Northern England. Therefore, they could be ignored by this or brought into it. We don't know.
Could they be considered local, in your opinion, if you are within half an
wrong.
hour of Berwick, for example?
Well, exactly. I don't think they're local in the way that Scottish Renewables and bigger economics consider it, because they assume they're selling this to the Scottish Government, and they're telling the Scottish Government this is the benefit that Scotland will get from this. Some of those will drift into, in my view, some of those could well drift into other parts in the UK, and the term that is used regularly in the document is could be.
I suppose it obliges me to ask you whether that document that you quoted to me by Bigger Economics, whether it, in your opinion, territorially locks its assumptions, or whether it is or is not doing that, in your opinion.
In my opinion, they are assuming that the benefits from developments in Scotland would all occur in Scotland.
And if they've labelled it as such, would that be a reasonable conclusion for any reader to?
I'm not sure it's labelled as such, but that would be my interpretation from the documents I've read and the way they present the results of their analysis. I'm not sure that quite answers your question.
No, I think it's clear to me where I think you're coming from. If you don't want to say any more, I'll let the council say more if it needs to before the applicant can then have heard everybody. Did you want to say any more, having heard that additional material?
No.
I'll turn to the applicant then. There's the points that I've raised, so I'm interested in obviously your response to those, but there were several matters which I've no doubt you'll want to address as well. So if you can kind of do all of those, then and in the order you see fit, that's fine.
Thanks. So yes, I'm going to deal with Mr. Whitfield's points about the existing use of the site and to dispel any concerns that there are on that matter. The site is in mixed agricultural use, but there's some other uses. There's a small quarry there's a motocross activity, there's some forestry, there's some arable land, and there's cattle grazing. The grazing activity would continue with the development in place. Also, the site is some 15% odd of the wider land holding, so the landowner has opportunities for grazing cattle elsewhere. The forestry, some forestry would be removed, but it would be replaced. There'd be no impact on the quarry, there'd be no impact on the motocross. So actually, there is no displacement of any activity in the farm unit. And furthermore, this is a form of diversification in the rural economy, and the landowner would secure some additional income from the development. The applicant has no control over how that is spent, but it could well be spent on further agricultural activity and indeed further diversification, potentially. But I don't want to speculate on that, but there's clearly the potential for that.
Mike, apologies, could I just interrupt you? You might be about to say it, but I think you listed a series of uses for the site which you said would remain unchanged. Did I miss, or were you about to talk about it, arable? I think you'd mentioned that was you, so I didn't know if you, I might have misheard, so I don't know if you quoted that, and whether that would continue or not.
I'd need to check whether the arable was impacted. My understanding is it's not.
The project's not located on any of the arable ground, it's only on grazing ground.
Yep. That's right. So that would not be impacted.
Okay, that's clear, thank you. Sorry I interrupted you, so just take a minute to make sure.
The point I was going to make was about the displacement. This is not like, say, a retail development where coming into a town there may be displacement of existing spend, which would have potentially a negative economic impact. So it is net additional spend and construction activity and within the area without displacement. So I think we can be confident that it is net benefit that is arising. It's not displacing another wind farm in this local area. Turning to your questions on the agenda, in terms of what paragraph C of policy 11 means, I think it's 3 years on since NPF 4 came into force. This is still a question at large, evidenced by today. We're dealing with it, and as Mr. Wise says, there's been no guidance on it. We do have, however, the benefit of nearly 50 Section 36 decisions by the Scottish Ministers, where they have considered the full suite of policies in NPF 4. And I'll turn to a couple of examples which I think will help, and that links to your last question about what factors would the Scottish Ministers look for. Now, putting it simply, what I would say it means is taking account of the predicted socio-economic benefits. And as Mr. Whitfield said, the term could was used. I mean, it can only ever be an estimate at this stage, but it is based upon knowledge of typical spend metrics which are set out in some national documents, and in the EIA report chapter the sources are referenced for the methodology. In addition, the applicant is an experienced developer, and one of the UK's largest wind farms is relatively close within the Scottish borders in East Lothian, Crystal Rig, which the applicant has developed over years. So they're highly experienced at procurement of the principal contract and balance of plant for wind farm developments. They have a mature supply chain actually within the Scottish borders and East Lothian of local supply companies, so they're well placed to understand what that net economic impact could be. In terms of the territorial scale requirement, I think Mr. White put it very well. you know, there is not any limitations on that, and I think that should be a clear point. I'm happy to go on to the other aspects and the examples I gave, if that would assist, or happy to pause there.
If you've got nothing more to say on the initial premise and C, we'll hold it there, because then we'll go back and we'll work our way through. I recognise that these kind of blend into each other and what have you. Did you want to say any more on C and on the what does maximise economic benefit mean, etc.?
Nothing further on that. I think I can pick it up when I respond to the last 2 points. Thanks.
Okay, everyone's been able to set out their position now on that particular matter. I'll see whether there's any responses to that. I'll let the applicant respond, and then we'll move on to the other ones. So, Mr. Whitfield and Mr. Campbell.
Yes, we do have something to say.
I think
in response to that.
the key point to what Mr. Bell's just said is that there is no evidence that that has taken place in this analysis. It may or may not have been. We cannot make that judgment. And if you read all the narrative that goes with it, it doesn't say that anywhere. And we've used the term could a couple of times here. The applicant emphasises that these are conservative estimates. We have no idea whether they, because there's no sensitivity around it that we can see, which is in the Good Practice Guide and in the Public Finance Manual I talked about. So there is no evidence that the could goes with the term conservative. So, for example, Mr. Bell's well made out that Fred Olsen are a significant player in the market, that they have other activities close by, that, without going into detail, they are a sister company of Natural Power. Natural Power have just put in a major control centre. So we have no idea whether there have been any economies of scale built into this, which you would expect an investment of this nature made by such an international company to be looking to make. So there's no evidence of whether that has been taken into account through this process. And my final point, just to reiterate what I've said before, there has never been any post-investment appraisal that goes with an analysis of this nature, and there's never been any peer review of the work that Bigger Economics does for the sector. Thank you.
Okay, thank you. That's clear. Did the council want to respond further on any points made so far?
No.
Mr. Bell, back to you.
So are you happy if I go on to the next question?
I'm just inviting you at the moment to respond to any of the additional points that you've heard. I realise some of them were previously made, so if there's anything further you wanted to say besides what you've already said.
Yeah, I would just say that Mr. Whitfield keeps repeating there is no evidence. There is a detailed EIA report chapter on this topic, which is before the inquiry. The council has accepted, but no party has challenged it as being deficient in any way in terms of any of its source references, apart from the parties here and their criticisms of it. Bigger Economics has prepared it. They're highly experienced and respected economic practice in Scotland. Their work has been repeated over numerous wind farm developments and other types of development in Scotland, and has been accepted by the Scottish ministers and indeed by many other planning authorities. So I would have full confidence in what has been set out. So nothing further to add on that sort of evidential criticism that has been made of the applicant. Thanks.
Okay, thank you. I recognise. Right. Okay. I mean, I recognise that there's a dispute, so I don't want to repeat what we've already said. So is it something additional, or is it a repeat of what's already been said?
Marginally additional. Mr. Bell has just reiterated, was reviewed in significant detail and critiqued by consultants on behalf of the government. There is no evidence that I'm repeating myself, I apologize. There is no evidence that bigger economics work has ever been peer reviewed or checked in this sector.
Okay, I'm clear on your points about that. The council wants to respond again? No? Yes? Further. Mr. Bell, did you want to say any more?
Nothing further, thank you.
Okay, right. I understand there's a difference of position. I understand why it is both parties have given me that. Okay, let's move on then to part D. And I have to point out a typo of mine, which is a slightly unfortunate typo given the nature of the discussion that we've been having. Can any reasonable...
Moving on to D.
Moving on to D, that's correct. Did you want to say more on C?
The territorial point. Have you dealt with that?
Covered.
Yeah, you're content to move on. Yeah, not a problem. Yep, okay. So part D, can any reasonable connection be made between EIAR, Environmental Impact Assessment Report, findings of relatively modest net socio-economic benefit and the above policy intent to maximise, and this should say maximise net economic benefit because that is what the policy says. Impact, my apologies. Two typos. So that's my mistake. So my intention there was to quote what the policy was seeking, maximise net economic impact. So I'll start again with Mr. Whitfield and Mr. Campbell, and we'll hear from the council, and then we'll hear from Mr. Bell.
I think without repeating what I've said before, this project, even on the applicant's analysis, produces negligible benefits, and I think I have questioned how much we can rely on that being conservative and appropriate without the evidence, and that evidence has been refused to us. So I'll leave it at that.
I mean, my purpose of asking the question, and you can clarify whether I had read properly what you'd put to me, but what I understood was that you were wanting me to view, and I might be wrong, you were wanting me to view the conclusions of the Environmental Impact Assessment Report that concluded negligible socioeconomic benefit. You wanted me to, I understood at least, you were saying that's quite small versus the principle of maximise. Have I understood that properly?
Yes and no. It's quite small, and you would normally expect to see in these circumstances, some sensitivity around the major assumptions that have gone into that to arrive at, is it negligible, is it plus or minus this or plus or minus that, and we don't know that answer. So even on the applicant's analysis, which we would suggest potentially has an optimism bias, back to those good principles, and there's no sensitivity analysis, then potentially this is at the optimistic end rather than the conservative end, and you have in front of you no evidence to make that judgment.
Okay, I understand that point from the points that you were making earlier in relation to that argument about net and conservatism versus something else. I had taken from it, and I just wanted to clarify again, and you can tell me if something is to be maximised, then is it to make itself the most it can be? You can tell me if that's the wrong definition. You can give me your own if you like. And
I think your assumption is that I may not put this terribly well, so bear with me. There are benefits to this project for the local economy and for Fred Olsen. And the question is, you can move some assumptions, and those benefits move between the government, the economy rather, and Fred Olsen. And somewhere along the line, a judgment needs to be made by Fred Olsen as to where those are maximised enough such that this project may go ahead. And that therefore the maximised question is, they have put their best foot forward and their best foot forward still says this is negligible.
Okay, and
Am I
I kind
answering the question?
of I think I understand what you're saying. There's kind of 2 points that occur to me. I'll make them both, and you can respond to them. One is you made a distinction between the developer and the economy. Would it be reasonable for me to assume that the developer was an actor within the economy, and therefore, just a second, it just occurs to me, is that distinction one that I should be making? And secondly, I was just trying to make sure I hadn't misunderstood your point. If maximise was making something the most it can be, and something is of itself negligible, and that is the most it can be, does the scale of something being negligible versus whether that is or isn't maximised, is that a dichotomy?
It can be maximised and still be negligible.
So I think that's the point I'm asking. So, okay, so did I misunderstand your argument?
It can be maximised and still be negligible. It can be maximised and be nil. It can be maximised and negative. Hence the word impact rather than benefit.
Okay.
And
None of it can happen without evidence.
yeah, and back to the evidence point, and back to your point of, is Fred Olsen a participant in the economy? Fred Olsen is a participant in the European economy because it's a multinational company.
But of course,
So,
in
yes,
that
yes,
example,
no,
this
so-
investment is in the United Kingdom and in Scotland within the United Kingdom. So there is. I take your point that
So I-
multinational companies may well move money around in ways that they're allowed to do, but
They can move things around and they can buy things in different sectors in different countries as well and bring them in. So,
as presumably could others.
as could others, but there may well be tax advantages, for example, in doing things in a different way. So,
Okay. Sorry,
yes.
I don't want to go too far down what is or isn't the case. I think we're drifting a little from my question had simply been you'd made a distinction between the economy at large and the developer, and the developer in this particular instance, but at least the principle you appeared to be making a distinction between those who would construct and operate developments such as this and the economy. And my question had been, are they part of that economy? And therefore, can I actually make that distinction?
yeah, so yes, they are part of the economy of Scotland. They're also a party to a wider economy where some other countries may not be. So other companies may not be, sorry.
Okay, thank you. I think I'm clear on the points that were made indeed. Did you want to say any more on D before I invite the council back and then the applicant? Okay, thank you. Did the council want to say anything?
No.
Thank you very much. Mr. Bell.
Thanks, sir. I think there's two matters here. One is EIA methodology and the other one is policy. And there has been a move in practice in the last couple of years away from including economic impact within an EIA report to a more standalone appraisal, an socio-economic appraisal. Because in terms of economic impact, the outputs are often hamstrung by the methodology when you look at the magnitude of an impact. And it's probably the case that in the vast majority of EIA reports that are prepared, the socio-economic impacts are concluded as being negligible in the methodology that's followed. But that's not to say that there would not be considerable benefits and valuable benefits arising from projects in terms of socio-economics. And what is set out in chapter 3 of my hearing statement, and there's more detail in chapter 14 of the EIA report. I don't think we need to go there, but there's clearly a breakdown of the construction and operational stage impacts. Then there is the community benefit payment, albeit I would flag that that's not material. Then there is the shared ownership offer, which is not often found in developments. This is one which offers that. And there's the additional point of the applicant being a developer, so it's not one that moves on consents to other parties to build. They are an experienced operator with, as I mentioned, that supply chain already established within this part of Scotland. So I think there is a distinction between the EIA report and then what you can take into account for the purposes of the policy. And I can move on to the couple of the examples I mentioned, perhaps to illustrate.
Yeah, I'm happy if you want to go
that.
there. Yeah, that's fine.
So it links in a way to the overlap to the last question about, what would help ministers. So there's two Section 36 decisions before the inquiry that I think are quite helpful, quite recent ones. One is called Bunloin, that's Bunloinn, which is a wind farm in the Highlands. The reference for it is 1220. And at paragraph 108 of that decision, the Scottish ministers say, whilst the overall net economic benefits are estimations of the effect of the development, the Scottish ministers are satisfied the proposed development has the potential for positive net economic benefits for the Highlands and for Scotland. And then the other relevant paragraph in that decision is 118. I'll read it. It's one sentence. The ministers state, the proposed development would also, however, bring benefits, particularly in terms of its contribution to renewable energy, climate change targets, as well as socio-economic benefits, such as employment and associated business and supply chain opportunities. And the last example I would highlight is the very recent USensis wind farm, and I'll just spell that for you. It's UISENSIS. So it was a Section 36 decision of the Minister's references 1237.
33.
Sorry, 1233, my apologies. And from paragraph 106 of the decision, the Ministers reference the GVA and employment effects that were reported in the EIA report. And at paragraph 111, they make this conclusion. Again, it's just one sentence, if you don't mind me reading it. They state, whilst the overall net economic benefits are estimations of the effects of the development, Scottish ministers are satisfied the potential for modest, significant, positive net economic benefits for the local community, the Western Isles and Scotland, weigh in favour of the proposed development. So that formulation of summary conclusion by the ministers is set out in the majority of their decision letters.
I would refer to these paragraphs which lead to that one. That's the basis on which it said that.
So just being highlighted that in the paragraph I read out, the preceding paragraphs are of some assistance, as I said, from paragraph 106.
So is that those preceding paragraph 111?
Yes, that's correct, in USensis. So the information that was relied on by the Scottish ministers, and indeed there was no inquiry there, so it was just the Scottish ministers, is very similar to the metrics that you've got for this project. The other point I would say is that the applicant does host what are called supply chain events. So to give you a very recent example, Crystal Rig 4 is just about to be energised. The construction is just finished on the main Crystal Rig complex, and the lead contractor was RJ McLeod, Scottish contractor, and they held local events which were advertised to secure interest from local suppliers. And just to give you a flavour of the type of uses they were looking for: fabricators, plumbers, fencers, joinery works, agricultural suppliers, timber, builder merchants, waterproofers, grouting works, builders, asphalters, white liners, traffic management advisors, accommodation suppliers.
Sorry, can I just jump in? Is
So
that written down somewhere? I was starting to
in
write.
my notes. So
It's where, sorry?
I've written it in my notes here.
Okay.
So, but I can certainly provide a short written note if that would help. One page.
Perhaps if you can put those in closing statements, that's fine. You can. I mean, people have heard those examples. I've started writing some down. You were speaking quickly, but I get a gist of what you're saying, and others will have had a chance to at least hear that as well.
So that's for the construction of Crystal Rig 4, but Crystal Rig has been in operation for, I don't know, 20 plus years, and there are established suppliers in Berwickshire, East Lothian, Scottish Borders, and I've got a list of 25 firms who are regular suppliers. So there is a lot of evidence that there is an established supply chain, that the estimates that have been prepared and reported in the EI report are pretty typical for wind farms of this scale. The Scottish ministers have regularly, consistently accepted the EIA report findings of other projects. We've given 2 recent examples, and overall my position would be that the policy requirement has been met insofar as we've looked at NPF 4 policy 11C, and nothing has been advanced to the applicant to go back to your point about making the most of it. You know, what has been missed? Has the applicant missed anything? Shared ownership provides the opportunity for further benefits, and the evidence is that contractor activity is seeking to maximise local economic benefit. And as we talked earlier, you know, that's not an exclusive matter. The benefits do not need to be local. That's simply one example that was given there. So I think that's the applicant's position. I would also just add, I think the council's taken a very fair stance. The report of handling broadly mirrors what I've said, but in a much more summary way. So I trust that's been helpful. Thank you.
Thank you for clarifying that. I realise we started to drift into bits of E, but we'll come back to E, so we'll hold off that. So if comments can stick with D in the points made, I'll let Mr. Campbell and Mr. Whitfield come back, because there's some matters of response there. So you can say what you want. We'll come to the council, and then we'll let the applicant close, if assuming there's nothing further.
If I may, Mr. Bell falls into the trap of optimism because of the way in which he uses examples of other development as precedent. They're only useful to you in my submission if you are aware of the circumstances of those particular cases, and you can see some congruence between what we're discussing here and what happened in those other cases. You don't need me to lecture you about the value of consistency in planning, but both of the examples cited talked about the potential for the maximization of economic impact. Now, that's to read the policy wrongly. The policy is quite an exclusive one. It says development proposals will only be supported where they maximize net economic impact, not, as Mr. Bell would have it, where they have the potential to maximize net economic benefit. So he is interlining the words the potential, quite understandably, and I see why he's doing it, but it is an optimistic reading of the policy. Ministers are entitled to their view, of course they are, but you have to apply the policy, unfortunately, and therefore you have to apply the wording of the policy. It's not maximization if you strive to do it. You have to demonstrate that you've done it. That's what the policy says. And if the answer is that the impact is negligible, well, that's fine, but you have to show it. So the point that Mr. Whitfield's making, and the point I'm repeating, I'm sorry to do that, is that we have no evidence. We have optimistic projections in the EIR, which are there for us to consider. Having considered them, we find a paucity of evidence. I think Mr. Whitfield wants to add something.
Mr. Bell makes a very logical list of the suppliers elsewhere that Fred Olsen used, and that they could potentially be used in this particular development. But the evidence of how those suppliers on that list compare to what was in the original proposal for Crystal Rig, we have no idea. We have no idea whether that adds up to 10 million, but the proposal had 15 million in it. So we don't know. It's relied upon by Scottish ministers, the information provided by the industry and by Bigger Economics in this particular case, and Fred Olsen, without any evidence that those supply chains have produced what was in previous proposals. It might have been 10% more, it might have been 10% less, it might have been 100% more, 100% less. We don't know. So we are,
can't make a choice.
yes, ministers are relying upon information provided by the industry that has never ever, I'm repeating myself, been peer reviewed and been checked. And there's been no post-investment appraisals, which I'm sure again Fred Olsen would do for their own investment, but the Scottish Government have never done that. My experience elsewhere bidding for government contracts is that's consistently done, and I don't know why it's not done in these circumstances. Back to my principal point.
Sorry, there's a further point.
Yes, go on.
A further point here. Ministers have to make a choice with every application that comes before them. And ministers have drafted and promulgated a policy which says only where they maximise net economic impact. So that is one of the criteria, one of the paradigms which ministers, one of the parameters which ministers will apply in making a decision. And if they're faced with a choice between a 6 turbine, 50 hectare, 70 hectare, whatever it is, solar panel and batteries at Lees Hill, or something which produces a better net economic impact somewhere else, they're going to choose the one that's better. Or they might.
But is there a comparative dimension to the policy?
Well,
Is that what you're saying?
there must be, because the policy requires absolutes. It requires only will be supported where they maximise net economic benefit. So
But is it not fair to say that the policy is asking me to look only at the proposal that I'm looking at?
Absolutely.
Right. So I'm not being asked to choose between this and other ones.
no, but on the ministry desk there may be more than one.
But presumably that policy wouldn't prevent them from doing. They could do all of them or none of them, could they not?
They could, that's the point. If they have certainty.
But you implied to me, I think, that there was a competition, and
No,
it
I'm not-
is
I'm not
okay.
implying
Did I misunderstand?
competition. I'm saying ministers will have a choice in consenting different applications, and so they will choose those, or they are more likely to choose those, I would suggest, which demonstrate that that net economic benefit is maximised.
Okay, I think I understand what you said. There was a point I was about to make, and I probably should have made it at the initial point where I thought about it. It may well come back to me as we go back through things. I'll ask the council if it wants to respond to those points.
Is this from Dunsleys Hill or that?
I'm happy if you've heard two things, so I'm happy for you to respond to either of those remarks, and then we'll let the applicant come
Okay. I think I'm just going to try and respond to D as it picks up a couple of those bits. In terms of the connection that's raised in Part D, whilst there is a connection, it is unclear that whether the development would maximise net economic impact. As I've said before, this is because there is no Scottish Government planning policy or guidance on this matter. But as the applicant has said in our committee report, we've summarised that whilst the Scottish Government onshore wind policy statement suggests and identifies a number of potential benefits, such as community benefits, shared ownership, and jobs, these cannot be secured or controlled by planning legislation. Saying this again, we accept the findings and that there will be temporary negligible positive effects on the local and national economy, and consider that there will be positive net socio-economic benefits in planning terms against policy 11 part C. I understand this position of the positive net economics benefits, positive. I'm trying to get your terminology right because I've written it down different. The net economic impact. This aligns with the Section 36 decisions that have been referred to by the applicant. So the benefits like these are identified in these decisions, and those by the applicant that I've suggested are considered to have varying levels of positive economic benefit, and they generally satisfy Part C of MPF 4 Policy 11. However, saying this, I just want to make it clear that it doesn't necessarily mean that these benefits make the Section 36 applications acceptable against Policy 11 in full and the overall plan and balance.
Thanks. Yeah, I understand the point that you're making. I've remembered the question that I was going to ask Mr. Whitfield and Mr. Campbell, so I'm going to ask that first. The applicant will have a chance to hear what that is. I'll let the council come back if it wants to say anything, and then the applicant will be in a position to answer. On the matters that you were talking to me about, I think before we rehearsed that last bit, in order for that to be true in terms of the understanding, we can't know absolutely everything now, can we? Because at least part of the certainty for a proposal of this kind is that it has an understanding of the types of work that will need to be done and the jobs that will need to be... So I don't want to use the word jobs. The human resource and financial resource and physical resource implications that go with that will require someone to do something. And it can't let contracts, it can't do any of those things until it has the certainty of whether it is going to be allowed to proceed to do the development. And presumably, therefore, I could only know the answer to some of the things that you're talking about at the other side of once the development had actually occurred, because I wouldn't, no one would know that, would they? Is that fair?
That's exactly why post-investment appraisals for previous projects and a sensitivity analysis would give you that evidence, which you don't have. So if we did a post-investment, going back to the example of Crystal Rig, if on Crystal Rig you knew that the proposal said this and the actual is that, you can then say, you know, if that's broadly what appears in this one, and then if it was plus or minus this little bit here or there, you'd have a sensitivity analysis, and then you have the evidence on which to make a judgment. You do not have that evidence currently.
Presumably it would be contextual, and I would have to recognise that it was contextual because there may be different circumstances and what have you.
Yes, but
in that example that you give.
Indeed, but
it has to mean something. The policy has to mean something, and what it means is, in my submission, is that you've got evidence that you can make the judgment which the policy calls for. So you don't have it. What you have are generalised, generic projections in the EIA, which are fine as far as they go, but they don't take you any nearer this project.
I'm asking, can anything else reasonably be done other than that? Accepting the point that you've just made.
yes,
of course you can.
Sorry, I interrupt you. Okay, I suppose the point I'm making is, which is different to the policy. I've got my finance and economics hat on rather than the policy hat on. So the point I would make is that I would have expected in these circumstances for the model to be available and for the evidence of how that's worked in previous projects across the hundreds that have been produced across the Scottish economy, for ministers to make the decision as to whether these are reasonable assumptions or not with a sensitivity analysis. None of that is available.
Okay, thank you. I understand your position. Right, that's we'll come to the council now. If you could, there's been a little bit more since you last spoke. Did you want to add anything to what you just said in response? Mr. Bell, then. So happy for you to respond to the various different matters. Mr. Trinick, perhaps.
Just I'll pass over to Mr. Bell in a moment, but what is effectively being asked for is a pre-development audit of a post-construction position, the economic benefits, which... can I please speak?
Let's let everybody have their turn. I know that... No, it's fine. We'll let everybody speak in turn because I can't hear everybody all at once. Okay, Mr. Trinick.
What's being asked for? As Mr. Whitfield and Mr. Campbell must know, it can't be done. All you can ever do is based in part on past performance and past delivery, which is evidenced in the chapter, to give professionally assessed estimates of the potential for maximisation. Meaning no more than doing the very best that you can to achieve the highest level of economic benefit attainable. And that, as a matter of common sense, is what the Scottish Government, Scottish ministers have recognised in the decisions to which your attention has been drawn by Mr Bell. Sure, we can have post-investment appraisals, but you've got to compare like with like. Different sizes of projects across different parts of Scotland with different demographics, different economic dynamics. You don't know you're comparing like with like. You've got to be very careful. All that we can do is to say we will do the very best that we can, and here is the evidence of that in the EIAR. And that is what has been done here. That is what has been accepted by ministers in the decisions recorded by Mr Bell. I'll hand over to Mr Bell to continue.
Thank you. I was just going to say that, you know, whether it's a wind farm development or a housing development, the economic benefits will be estimates, and that is just a characteristic of the planning system and the stage of the development is inevitably at. I think an added factor is that this is not a novel type of development that is coming forward, and the economists that work on these projects also use, and it's set out in the EI report, estimates per megawatt of spend, and that has been based on research undertaken by the UK government over looking at various developments where there has been sensitivity appraisals. So, you know, the source data that is used is robust. That's set out in the EI report. So I don't think I need to say any more on that. The last thing I wanted to say, though, was just that in terms of the wider policy context, in my hearing statement, I referred to the Green Industrial Strategy, the latest economic strategy document of the Scottish Government. And the first of 5 opportunity areas is maximising Scotland's wind economy, onshore and offshore. And it refers, this is in my hearing statement, paragraph 2.6.6, in terms of consulting, that's pre-development activity, operations and maintenance and supply chain, key terms, which the applicant has explored in the EI report and provided figures on. So I would say it just adds to the factor that the Scottish ministers would want to take into account. Your last question is alignment with the Green Industrial Strategy. Thank you.
Okay, thank you for that. That is, I think, bringing us into Part E. So let's progress into Part E then. I realise we've touched on that, but I think let's give it its outing. So, what factors would help Scottish ministers to determine whether net economic benefit would be maximised if proposals such as this are approved? So, Mr. Campbell, Mr. Whitfield.
Just to go back to what Mr. Trinick was saying there, the point of the matter isn't necessarily that you want to do a post-investment appraisal in advance. The issue is, to use a different word to evidence that I've used before, that this is not transparent to the reader as to how it has been arrived at, and that having asked for the model so that we could do some analysis of that, and it doesn't appear to us that anybody else has done that before. I think the lack of transparency is such that you are being asked to rely upon the applicant's analysis without evidence. I'm repeating myself, so I'll stop.
Okay, thank you. So, I mean, that was a response to that, and the applicant will be able to come back if it needs to when we get to that. On the points in Part E, though, specifically, what factors would help Scottish ministers to determine whether net economic benefit would be maximised? I mean, you've told me why you think I possibly can't rely on that. Do you have is there further information you want to give me in response to that particular matter? Nothing further. Okay. Do the council want to say anything?
Yeah. I think as before, whilst the onshore wind policy statement from the Scottish Government does provide some guidance on maximising these types of benefits, there is no plan legislation or plan legislation to secure or control these benefits and ensure that they are maximised. Other legislation or agreements between the developer and community may contribute towards achieving this. However, this is a non-planning matter outside my expertise and outside the council's involvement as a local plan authority. However, generally, the benefits outlined by the applicant in their EIR are acknowledged in good faith by the council and that they will be appropriately secured. Thank you.
Thank you for that. So, Mr. Bell, Mr. Trunick, what I'll invite you to do first is to just respond to any matters, cover anything you want to under Part E, and then when we've done that, I'll let you close overall. Nothing further.
No, not Part D, on to Part E now. Yeah.
So on Part E then, yeah.
Thanks. The factors to take into account are referred to the two decisions. I won't go back over that again. But
yes, I've got a record of those, the EU census and the...
Especially EU census, where it's from paragraph 106, where the ministers go through the references excuse me, to GVA, to employment creation figures, both during construction and operation, and also reference supply chain effects. So I've sought to summarise some of that information in my hearing statement, Chapter 3, but if you wanted more detail, that's in Chapter 4 of the EIA report. I also flagged up the reference to shared ownership discussions that are continuing, and also the reference to established supply chains already in place within the Scottish borders excuse me, that the applicant has. So I think those points together, looking at the existing decisions plus what's in the application information, is what excuse me.
Right, no, just take a minute, have a drink, and then when you're ready, just carry on.
Excuse me. So it's really these two sources. Thank you.
No problems. Okay, thank you for that.
One final thing.
Oh yes.
The onshore wind policy statement is helpful. From page 29, which references supply chain, and there may be sections within there that would flag up some further relevant information, mainly for your note, to look over that in the similar way that I highlighted the green infrastructure strategy.
Saving Mr. Bell's voice, I think he's coughing away there. In section 521 of the onshore wind policy statement onwards, I think that gives an indication of what the Scottish Government is actually looking for in terms of maximising benefit. In other words, the way it looks at things, it refers to the creation of jobs to date, full-time equivalent jobs in Scotland from onshore wind development, what may happen in the future in terms of direct and indirect jobs, referring to the Scottish manufacturing supply chain for the industry needed to be strengthened. It looks to what it wants to achieve, and I think that might help you under Part E.
Thank you. I'll let you come back then, and we'll just have a discussion on that matter.
Thank you. The paragraph referred to is simply a statement of aspiration. Yeah. Actually, it's not even that. It simply says Scotland has a well-established energy supply chain, boasts an incredibly skilled workforce. It doesn't say that is the Minister's aspiration. So again, it's not permissible to read a policy document in a way which it doesn't express. That's probably a lawyer's approach, but nevertheless, it's a fair one. You can't read into the policy words that aren't there. It's simply a statement in the policy statement. It's simply a paragraph in the policy statement which says what we all know, which is that Scotland's got an energy supply chain and a skilled workforce. We know that. But it doesn't express a policy to engage with that. Maybe obvious, you may think it's obvious, it doesn't say that. Sorry.
I think Mr. Trinick gave some numbers as to what has been delivered by the industry. Back to my point, to repeat myself yet again, we have no idea what the cumulative EIA socio-economic benefits were that compare against the jobs that have been created. So let's say we've created, I don't know, 1,000 jobs. We don't know whether the cumulative EIAs that have contributed to that said there should be 2,000 jobs. We don't know.
Okay. Thank you very much. Council, anything more? Nothing more from the council. So in a minute, I'll let the applicant just respond to those points, and then after, I'll see if there's any more, and then we'll invite the applicant to close. So, Mr. Trinick.
The reason I drew attention to the onshore wind policy statement was simply to address your point E only. What factors would help the Scottish Minister determine whether net economic benefits have been maximised? The onshore wind policy statement gives a way that the government thinks about this issue, and that's why it helps under Part E. That's my reason for drawing it to your attention. Thank you. And we've got no closing comments to make.
Okay, if there's no more? No? Said and done? Okay, and you just said to me there were no closing remarks you wanted to make? No. Okay. Thank you all. That brings to a close the policy hearing session. Thank you very much for your contributions to that. We will take a break just now. That's just gone 11:30. So I think we'll have 15 minutes. Let everyone get their heads back together, and then we'll come back and do conditions. So back at 11:45, please. Okay, ladies and gentlemen, let's carry on. So another good morning. We're now at 11:45 on Thursday, 15th of January 2026. If you're just joining us or just tuning in, we are now about to commence the hearing conditions session, having completed the policy session 15 minutes ago. I'm not going to go through the remarks that I've already made this morning about housekeeping and various other matters. Well, I think everybody's aware of those, so we'll just carry on. But I think we will do some introductions because we are joined by Mr. Smith this morning. Welcome, Mr. Smith. You've been sitting in the audience listening all week, but for this particular session you'll be joining us. So I'm going to go around in a minute. I'll get the applicant to introduce themselves, everybody else, and then I'll invite you to do the same. So Mr. Trinick, please.
Thanks, Marcus Trinick, Solicitor of King's Counsel, instructed by Amy Howard, who sits two to my left, who will do the talking in this session. And to her left, will also do some talking, Emily Galloway. Thank you.
Thank you very much. Counsel, please.
Good morning. My name is Sarah Thompson, Solicitor for Scottish Borders Council, and I'm joined today by Kyle Wise, Planning Officer, and we will be sharing responsibility in relation to this session.
Thank you very much. Mr. Campbell.
Thank you. Good morning. I'm John Campbell. I'm a retired advocate in King's Counsel. I'm part of and I'm representing Duns Leeds Hill, the third-party group in this case. Where necessary, I'll be speaking in this session.
Sorry, you'll be speaking today.
Mm-hmm.
Thank you. And Mr. Smith.
Thank you very much. Tony Smith, private individual. I am a consulting structural engineer and project manager.
Thank you very much for that. And I suspect I should probably just clarify for everyone's benefit. You've introduced yourself as Tony Smith. You're down, I think, in some cases as AJ Smith. Is that correct?
Sorry, AJ Smith, Anthony Smith, but Tony's the four-letter one that works.
And I suspect I should probably clarify for everybody as well. There's a great many Smiths in the country. If you can just tell us about the update first, we'll hold off jumping into matter one.
Thank you. Yes, so as per my email that I sent yesterday, discussion between ourselves and the council has been ongoing. I think, just looking at my email, there's probably three main conditions where there has been progress. The first relating to borrow pit blasting, which is matter one. I'm not sure that the condition is necessarily quite... the wording is necessarily quite agreed, but the principle of having a condition is, whereas it wasn't previously. And in relation to the other two conditions, which is matter 3, private water supplies, and matter 5, enabling works, the applicant and the council now have a agreed position in respect of both.
Okay, did you want to say any more about that before I'll come back to the council?
No thanks.
Okay. Obviously, we're not on matter one yet, so if you can just say anything you need to say there.
In relation to matters 3 and 5, we are at an agreed position. I don't know that, subject to any commentary from other parties, that there would be anything to address under matters 3 and 5. Matter 1, the principle is agreed. I think it's just that there'll be a couple of matters where they're not necessarily dispute, but simply just to clarify in the course of matter 1.
So there will be an opportunity for, when we get to those relevant points of the agenda, we'll hear a little bit more detail. I will invite comment from all parties. I realise, Mr. Campbell and Mr. Smith, you've had a little bit of time to view that, but you may not have had a huge amount of time to take it in or reach any conclusion. Before we get into the detail of all those, did you want to say anything just now?
No, I don't, thank you.
And Mr. Smith, did you want to say anything just now before we get into the agenda and the detail with each one?
Just that I haven't received it.
I'd seen that I'd seen. I'm not going to read out the email address here. I'd seen an email address which I took to be yours. Perhaps, Ms. Howard, at some point during the morning you can liaise with Mr. Smith to make sure that the correct contact has been made.
Yeah, certainly. I thought I had. I've used the email address I've got for you, but if it's not reached you, I can definitely make sure I've got the right one and resend.
There will we will be dealing with each matter as we go through the agenda in any event, so I'll invite you to do that. And the further point that I was going to make, and I think this has probably served to illustrate it, is that obviously it was yesterday, so given the level of notice to parties that are not either the council or the applicant, when we get to that matter, if you're not in a position where you feel you can answer, I would be happy for you to put those things into closing submissions so you can have a little bit. The agenda reads, the council proposes a new borrow pit blasting condition. The applicant argues it to be repetitive and unnecessary, as this will be covered by the permission for the existing quarry that is within the proposal site boundaries. Part A, I had asked, is the whole of the preferred borrow pit area shown on Environmental Impact Assessment Report, EIAR, figure 1.2, covered by the existing quarry permission and its conditions? And part B, the Environmental Impact Assessment Report, EIAR, figure 1.2, includes 2 optional borrow pit search areas in the southern part of the site. Would those be covered by the same quarry permission and conditions? If not, would the council's proposed conditions be needed to cover their operations in the event of approval? So I think the indication that's been given to me this morning is that the matter has been somewhat overtaken by events. So I invite Ms Howard just to explain the position that the council and itself are in, because I think you're effectively putting to me a revised proposition of what such a condition ought to be. So I'll let you tell me about that, and then I'll invite the council to confirm matters.
Thanks, sir. Yeah, just to answer the question on the agenda, I can confirm that the application seeks consent for borrow pit areas which are outside of the existing quarry, and for that reason the applicant does accept a borrow pit blasting condition. So our previous comments referred to in the agenda no longer stand. I, in my email sent yesterday, have included the applicant's proposed wording for the blasting condition. It is very similar to the wording requested by the council. There's just a couple of sort of minor differences. I could go through those if you'd like me to.
Yeah, it would just be helpful to highlight those, I think, if for no other reason than for me to understand what they are, and for other parties who might want to comment at a later point so that they do. So yes, please do that.
Sure. I think my understanding is the only 2 sort of areas of difference is the council's condition seeks to specify ground vibration limits, whereas the applicant's preference, due to the sort of technical nature of that information, our preference would be for that information to be provided at the time that the statement is submitted to the council for its approval, and that, you know, the limits can be agreed by between the applicant and the council at that point. And in terms of the hours of restriction in which blasting can take place, the applicant has asked to align those with the construction hours which are specified in condition 21.
So in relation to the ground vibration matters, there's not, did I understand properly, that there's not a dispute about that information being provided. The area where agreement is yet to be reached is on whether that forms part of any statement that's submitted as part of the condition prior to approval versus whether it's stated in the condition. Is that correct?
Yes, that's right.
Did you want to say any more before I invite the council to come back?
No, thank you.
Okay, so to the council, did you want to A, confirm that that's your understanding, and say any more if you feel the need?
I think we're in acceptance of what's being proposed in terms of the ground vibration limits and the locations of them. I think it's just the hours of the blasting is what we disagree with. What we suggested was on Monday to Friday, 10 a.m. till 4 p.m. and Saturdays at 10 a.m. till 12 p.m. and no blasting on Sundays or public holidays. I believe the applicant wants the hours to reflect what have been suggested for the construction hours. However, what we've proposed is the standard onshore sort of wind condition and the timings they propose, because it kind of reflects the sensitivity and I guess how loud blasting can be for sensitive receptors such as residential properties. And so we've suggested to what the standard timings were, and these have been endorsed by our environmental health officer, so we're quite keen to keep them as they are.
So did I understand properly in your remarks there, I think although Ms Howard had indicated initially that the ground vibration, the place where that information is contained was yet to be agreed, I think you were saying actually you don't dispute the idea that that would be something that would form a component of the statement. Is that correct? Okay, so there's possibly a matter of agreement actually there, and the only sole remaining bit is the disagreement on the timings. I'll invite Ms Howard back.
I think the only thing I would add is that the hours that the applicant requested are the hours which were assessed in the EIR noise assessment.
And just to assist me with the hours that you had assessed, were they longer operating hours than those proposed by the council?
Yes.
I recall that they were longer on a Saturday, and can you remind me, was it longer for all of the other days?
I think so. So for Monday to Friday, the hours we've suggested is 7 to 7, whereas I think Kyle might have said 10 to 4.
Monday to Friday, and then was Saturday the same as the council?
Saturday we've proposed 7 until 1.
And would it have been the same for Sunday and public holidays?
With no blasting on Sunday or public holiday.
Thank you, that outlines that. Did you want to say any more? I'll invite the council back.
No, thank you.
Did you want to say any more about that? I'll come to Mr Campbell then. Mr Campbell, you've heard the revised position pending certain aspects of agreement between the applicant and the council. Did you have any thoughts that you wanted to set out on what you've heard?
Yes, I did. I do rather. I wonder if the applicants can reassure us that the gas pipeline operator has been consulted or will be consulted in connection with the matter of blasting. The plan seems to show 180 metres from the gas pipeline for the proposed bore pits, plural. And I wonder whether, I'm not suggesting that it should be a condition necessarily, but you might think that that would be apposite, whether consideration has been given to consulting the pipeline operator.
Are you in a position to answer that?
Yes, I can confirm that National Gas have been consulted throughout the project design process and have signed off on the project layout and have no concerns with the border pit locations.
Any more, Mr Campbell? No.
No, thank you.
Okay. Mr Smith, did you have anything you wanted to raise at this stage? Okay. As I mentioned at the outset, if each of you are entitled to, given that you received the condition 9, and I should clarify for everyone at home, that's Mr AJ Smith, who is sitting opposite me. Proposed condition 9 seeks a detailed transportation study for the whole life of the proposal, and my question at part A is whether this matter is already sufficiently covered by draft condition 22 traffic management plan. And although I've only mentioned draft condition 22, I note that draft condition 23 is covering abnormal loads, and that might have been something that you were possibly interested in. I'll invite you to speak first, and then we'll kind of come back the other way.
Thank you very much. Just to confirm that I have found the email, and it did come in last night, so I apologise to...
Oh, I'm grateful for you confirming that, thank you. My offer still stands, obviously, about the closing submissions. You give yourself time.
No problem at all. The traffic management plan is very good. It certainly covers the initial construction. What it does not do, however, in its present state, is look to the whole life addition of vehicle movements throughout the area to complete the ongoing functioning of the installation. At the present time, everybody seems to be focused on the fact that it's 20 years, according to, it's 35 years is the duration designated by the applicant. It is likely that the turbines or the blades will have to be renewed within 20 years. It is also likely for the batteries and bits and pieces on the ground that they will need to be replaced at least every 15 years, given current understandings of the technology. I do believe that this will or could impose quite an additional number of traffic movements throughout the area, which, whilst individually for this particular development may be modest, could have cumulative effects with other developments in the area, and would just like to see the traffic management plan extended over the period of the project's operation.
And so, did I understand correctly? So it's that whole life duration which is the matter of concern to you. It's not necessarily the project. Try again. It's not necessarily the transport plan that is there. It's the fact that, in your opinion, it does not appear to apply beyond the point of construction. Did I understand you correctly?
That is absolutely correct. What it doesn't do, obviously there's going to be a peak number of traffic movements as the project is developed and installed. There's going to be major dislocations as blades and bits and pieces are delivered. That goes with what is going on here. But what is not taken into account is the ongoing additional traffic requirements for the area, for maintenance and for replacements over the 30-year period.
I see, and it's that you would like to see covered by the condition to ensure that the relevant plan includes that information.
It would be, in my mind, absolute necessity to include lifetime traffic movements, and I recognise that they will not be absolutely accurate, but they would certainly give traffic planners an indication as to what additional movements could be foreseen within the area.
Okay, thank you for clarifying that. Did you want to say any more before I invite others to comment? No? Okay, thank you. Mr. Campbell, did you want to say anything, having heard what Mr. Smith has to say?
No, we don't have anything to say about this.
What about the council?
So this is not a matter raised by our road traffic team, so the council remain fairly neutral in relation to this. Amendment has been proposed as condition 22, but that can perhaps be addressed at matter 6 where it is referenced.
I take it that particular matter it doesn't relate to this.
It does not relate to this.
Okay, yeah, I'm happy to pick that up later then in that case. And sorry, you said
this was not raised by our road traffic team as being something that would be necessary to condition.
Okay, thank you. Ms. Howard then.
Thank you. Yeah, I think I would just add that so the traffic and transport assessment is provided at chapter 12 of the EIER. No likely significant effects are predicted for any phase of the development, including construction. There's also an assessment of the operational period, which the effects are obviously considerably less. The developer could provide at the point of discharging the traffic management plan condition a best estimate of the likely operational traffic requirements, but it would be just that, a best estimate. That information wouldn't be confirmed until they had gone through the procurement process. And obviously there's an element of uncertainty as well as to, you can't necessarily predict if something needs repaired or replacement, so it would just be an estimate, but that certainly could be provided at the point of discharging the traffic management plan condition.
So I think I picked up, I think there were two things I was picking up. Firstly, did I understand then that the maintenance and ongoing maintenance and related issues that Mr. Smith was referring to, those are, by your understanding, covered. First of all, in the assessment has covered those. So there is an understanding of the environmental impact assessment findings that include, but perhaps aren't limited to, but include the operational phase, which includes maintenance. Is that correct, first of all?
Yes, that's my understanding. There's an assessment of the operation.
So first of all, if I was to look at that, I would have an understanding of those matters. And then secondly, are you saying in the event that consent was granted and that the condition as written was imposed, would you then need to seek additional consent to carry out any of the maintenance that is being referenced? Or would that be covered by the consent stroke permission in the event that approval was given to this?
Yeah, so if there was any abnormal load requiring to travel on the public road network, there's restrictions sort of in place. I don't personally know the procedure myself. I'm not sure if Emma can speak more to it, but
the Roads Act covers that, and we have to follow Roads Act procedures, so it's already covered by other procedures other than planning procedures for abnormal loads.
Yeah, I mean, you can probably sense what I'm trying to get to, which is an understanding that if the condition only covers the construction transport management plan, does it by default not cover the maintenance management of traffic? And therefore, by not including something of that nature, is it missed? And if it's missed the points that Mr. Smith is raising for us about whether there are potential impacts, how might something like that be addressed?
The impact's been assessed in the EIAR. There's an assessment of the operational phase of transport in the EIAR.
I mean, I recognise that
yeah.
there's been an assessment of it, and it's been able to conclude whether the effect would be significant or not. But in terms of mandating any particular action through condition, if the traffic management plan is only covering construction and there are similar effects at a later point, is there an obligation through the condition to, I don't know, I'm off the top of my head, to use that transport management plan as the basis for carrying out any of the maintenance exercises? And if that is the case, is there a clause within the condition that requires that?
Just come in there. I don't think such a extension of the condition will be necessary or reasonable. If works beyond people simply arriving for operations and maintenance in vans, if more traffic is required during the operational phase, it will be because some bit needs replacing. And that bit will be a blade or something like that, or a transformer. If that needs replacing, those will be abnormal indivisible loads, AILs, and they are controlled under the Road Act. We can't move those loads without the involvement of the police. So there are existing controls in place to cover those movements. Other movements involving HGVs and what have you in any quantity are not anticipated at all. They're not going to be necessary. It's only going to be the replacement of big bits that causes traffic. Thank you.
And just on that latter bit to do with abnormal loads, there is a condition on abnormal loads, is there not? That is, and that was a matter, I think, of agreement between the applicants and the council, by my understanding. Was that correct?
That's correct, but that would only cover construction in itself. So I don't want to overplay that.
No, it's helpful
but
to
the fact
clarify.
is there are other controls in place for the operational phase should AIL movements be required.
And in the event that consent and permission were granted, by virtue of that grant of consent and permission, presumably that would permit the delivery and removal from the site of materials. And in that instance, you're saying to me, I think that the Roads Act controls particularly large movements that are abnormal, but otherwise that is treated in the same way as any other development, where if it's there, vehicles can go to and from it depending on their duties. Is that fair?
Correct.
Okay, thank you. Mr. Smith, you've obviously heard what the applicant's got to say in response to the point, and some of the, I was rehearsing some points with it there as well. Did you want to respond then to the points that have been made? Was there anything that you picked from that you wanted to take issue with?
Thank you very much. Yes, just moderately take issue with. The applicant has stated could. The reality is that all of the batteries will need to be replaced, certainly twice in the lifetime of the site. So we shouldn't be blithely disappearing down the road and assuming that we're just going to have a white van man rocking up once a week. There is going to be a major disruption halfway through the project's lifetime, at the very least, for the batteries to be changed. The solar panels are also likely needed to be changed at a 20-year interval. And on current evidence, it would normally be somewhere in the region of 20 years that we'll be looking at replacing the blades. Thank you.
And so, in your opinion, you appear to be saying to me then there's a traffic management plan for the construction phase, but at a series of points during the lifetime of the proposal, effectively that process is going to be partly or wholly repeated. And your interest, as I understand it, is where is the mechanism to control that in the same way as there is one at construction? Do I take that as being correct?
I understand, yes, that is correct. I do understand that if a blade breaks, you're going to need an individual blade to be replaced. But if we're looking at wholesale replacement of large components, one surely should take that into account at this stage, or at least flag the possibility that it is going to occur.
Because I took it from what you were saying. I'll give the applicant a chance to say whether it agrees on the kind of the lifetime suggestions that you made. But I took the point to be that there will be a point at which multiple components reach the end of their operational lives, which might well be similar, given the number of them and the fact that they were all put in at a similar time. Is that correct?
That is correct.
And it's that effective potential part or whole repetition of the construction process that is the thing that is quite of concern to you.
I just don't believe we should blithely go into the project and assume that that isn't going to occur, when in fact it must occur on today's evidence.
Thank you for that. Did you want to say any more before I come around? No? Okay. Mr. Campbell? Nothing? No? Council?
Nothing.
The applicant then?
We simply don't accept the premise that Mr. Smith sets out. No disrespect to him, but he's got no evidence that these parts or batteries will need, or solar panels will need replacing at the intervals that he says. We do not accept that. If plant is properly maintained, it will not need to be replaced. There's no evidence before you to the contrary. So the premises are misplaced, and we don't accept what is said. We do not accept the need for any operational control during the operational phase of traffic beyond the AILs, which we've already dealt with.
So do I take it then that your contention is that, and you alluded to it earlier, but if there is any need to replace a component, it's because it has broken for whatever reason, and therefore that is a one-off? Or, well, it might happen more than once, but it's an individual thing on its own. It's controlled in the ways that you said.
But it can't be predicted, that's for sure, and it'll be a one-off.
I'll let you respond if you want to.
Thank you very much. No, I haven't put any evidence before you, so council is definitely correct.
Sorry, the applicant.
The applicant. Whoever it is there, I do apologise to him. At the end of the day, I will put in my closing statement something that backs up that contention that I've put, and if I'm not allowed to put it in, you needn't read it. Thank you.
Mr. Trunick, you wanted to. You were making noises to me. I think for everyone's benefit, I'd like you to say what you were going to say.
I don't want to see any new evidence in closing submissions.
That is a fair point. The intention of closing submissions is not to introduce new evidence. So anything that is introduced as new evidence, I'll be treating on that basis. Did you want to say any more on that particular matter, Mr. Smith?
What I would say is that I will not be introducing new. I did raise this in the statement that I put before you, which has allowed me to sit at this table.
I recall points that were made certainly about lifetime. Forgive me, I can't quite recall whether you'd submitted detailed information about that. I do remember you mentioning lifetime and durations, but I don't know if I recall more evidence than that.
Apologies, I didn't submit anything further than the submission that I gave to you, but it was recorded in there, these dates and these indications.
I have recollection of that. So yeah, so for clarity, yes, you had already raised, I think, the lifetime durations that you contended earlier for us when you were speaking. I can't quote whether they were the exact ones, but I certainly recall from your submission that you had mentioned them, so that doesn't prevent you from relying on those in future. I understood Mr. Trunick's point to be that if there was something additional to that that you considered to be evidence to support those, to substantiate those contentions, then in his view that would be new evidence. First of all, Mr. Trunick, did I understand you properly? Well, I was just rehearsing with Mr. Smith there that he was saying that he had, in his previous written submissions, advised of what he understood to be the lifetime durations of the various pieces of equipment. So that on its own would not be new, but I understood what you were saying is that if he wanted to submit additional evidence to substantiate that, then in your mind that would have been new. Did I understand you properly?
Correct.
Yeah, the point's made. Any more on matter 2 for anybody before I invite the applicant to close? No? Did you want to close? Nothing? Okay. Right. Thank you everybody. We'll move on to matter 3. This is one of the matters that Ms. Howard referred to earlier. So this is private water supplies. So I'll read the point on the agenda first and then we'll hear from the applicant. So the applicant and the council have alternative views about what draft condition 30 private water supplies is for and what it should say and do, as demonstrated by their respective proposed wording. Point A, which is the only point, what is this condition intended to achieve? So over to Ms. Howard.
Thank you, sir. Yeah, so just to confirm that this condition is now agreed to, between the applicant and the council. In terms of what the condition should achieve, just for your note, this is set out in paragraph 9.1.7.12.
Sorry, do you want to repeat that?
9.1.7.12.
Okay.
Technical appendix 9.1, and that's document number 1.179.
1.179.
Yes. And I'll just read that out just for everyone in the room. 9.1.
So you're proposing to read the condition. Is that what you're proposing to do? I'm happy for you to do that. Sorry.
Not the condition, just the paragraph.
Yes, on you go. Yeah, that's fine.
We'll do. So prior to the construction phase, a private water supply monitoring plan and method statement would be developed. This would detail all mitigation measures to be delivered to secure the quality, quantity and continuity of all private water supplies which could potentially be impacted by the proposed development. It would also detail the proposed monitoring to be undertaken of the private water supply at Lantern Leys Agricultural Spring, which was assessed to be at a low combined risk from the proposed development activities.
Thank you. Did you want to say any more?
No thanks.
Okay, and in the email that you'd sent yesterday, so myself, the council, Mr. Campbell and Mr. Smith have, even if not everyone's had a proper chance to read it, there is condition wording in there. There are 3 points to it, and from what you were saying earlier, that is now the position agreed between yourself and the council. So I'll come to them in a minute, but yeah, that's okay. So when I read that wording, that is, to your mind, the proposed wording that both of you agree on that I should take in place of anything previously stated.
Yes.
Okay. Did you want to say any more on that particular matter before I invite the council?
No, thank you.
So do you want to just confirm and say
Yes, I would
views?
just confirm Ms Howard's position, and the wording in her email of yesterday morning is the agreed position in terms of this condition.
I'll come to Mr Campbell first. Mr Campbell, obviously you've perhaps not had a great deal of time to look at this. It might be something you want to raise points on now or wait till closing submissions. It's entirely up to you. It's the position that they've agreed on, but that doesn't oblige you to agree with it, of course.
Thank you very much. Mr Whitfield's got an observation to make, I think.
Mr Whitfield, do you want to pull the mic a little bit closer to you?
Yeah, sorry, just clarity really. I think what Ms Howard's just said is that there's a protection for an agricultural spring, but there's no protection for the private water supply to Old Langton Lees.
I'm happy for you to respond to that. Yeah. Can you switch your mic off, Mr Campbell, please?
No, that's not quite correct. So the condition will ensure to ensure the, just to get the wording right, the quality, quantity and continuity of all private water supplies, which could be potentially impacted by the proposed development, with specific reference to the Langton Lees agricultural spring. The applicant has proposed to carry out monitoring, and the reason for that is that in terms of the risk, the private water supply risk assessment, that was the only source that was identified as having a risk of low.
Of any risk, yeah.
For all other supplies, the assessed level of risk was negligible. So that's the reason why that one has the proposed monitoring in addition.
Okay, so when your expert came out to my house, neither of us knew where the water was coming from, and I don't know how it was assessed then as anything other than there is a risk. Sorry, my question is quite simple. Have I got security of supply through this development or not at Old Langton Lees?
I'm happy for you to answer that, insofar as you can.
Yeah, just insofar as I can, yes, it's been assessed in the IER, the risk was assessed as negligible, and then there's the condition offered as, you know, additional protection.
Go on.
I'm not sure I followed that. If there is an interruption or a quality issue at Old Langton Lees, does this condition cover me with you supplying a new water supply to Old Langton Lees? Appreciate there's a few ifs in there.
Yes, so the condition applies to all water supplies that have the potential to be affected, and Part C of the proposed condition includes proposed contingency plans in the event of an incident attributable to the development resulting in an adverse effect on any water supply identified under Part A, and Part A refers to all private water supplies that have the potential to be affected by the construction activities.
I mean,
I'll take that as a yes.
okay, fair enough. I mean, you have the opportunity to respond to this in your closing statement. I suspect you'll want time to study it for what are obvious reasons that you've indicated. I think Ms Howard's taken you through that. I note in Part 2A it does say all private water supplies, so that's just, I think, repeating the point that she made, and it does talk about contingency planning. But I will, if I see in your closing submission material relating to this, I recognise that you've had not a lot of time to study it, and that's right. And the applicant will be able to respond, obviously, to the comments that you raise, and I'll have a position on that. So, did you want to say any more? Okay, Mr. Smith.
No, thank you.
Very well. Has anybody got anything more on matter 3 before we move on? No. Okay. Did you want to close or anything?
No, thank you.
Fine, right, that moves us on to matter 4, post-operational decommissioning and restoration. We'll be returning then to Mr Smith in just a moment, but I'll read through the agenda matter on this. So, Mr AJ Smith proposes condition 7 on page 6 of his statement emailed on the 25th of November 2025. So there are 2 parts to this, I think we'll take them both together. Part A, are these matters adequately covered by draft condition 35, site decommissioning and restoration? I should point out a typing error of mine, because I think this is actually called site decommissioning, restoration and aftercare, so my apologies for that. And also draft condition 36, which is financial guarantee. as part and parcel of this, and/or the council's proposed condition entitled Decommissioning, Restoration and Aftercare, which proposes an interim strategy for that purpose at the outset, and if not, what is additionally needed. So, Mr. Smith, I suppose I'm asking you a slightly complex question. In a sense, you've put forward things in your condition 7, so I'm asking you initially if those 2 conditions that the applicant had put forward, part of which I believe is agreed with the council, whether that does the thing that you're saying you would like, but the council has put forward, I think, alternative wording for the decommissioning, restoration and aftercare, which you may or may not prefer instead. So I'll invite you to say what you want to say.
Thank you very much. Yes, I agree with it almost. Okay. So with regards to the decommissioning, that's 35. I'm quite happy with that. With regards to 36, para 2, I believe that it should not be merely left to the company and the planning authority. I believe a suitably qualified independent professional, or in fact I suggested professionals, put forward the sum that should be held as a financial guarantee.
Because I think you mentioned, didn't you, an
I said
independent surveyor or actuary?
I indicated quantity surveyor and actuary, one for the duration, one for the realistic assessment of the disestablishment.
And is it that particular point, is it that kind of independent oversight which is the point of concern for you? You mentioned you were happy otherwise. Do I take that to be the issue of difference?
That is the only issue of difference is in para 2 of 36, where it says at the moment that it shall be agreed between the company and the planning authority, or failing agreement. And I would suggest that in fact an independent person put to both parties the sum that should be accepted as the guarantee. And
in the event that it, we'll hear what people have got to say, but in the event that by the nature of conditions it must be the planning authority and the applicant, it must be the parties that are listed that agree, would it be your preference or contention that the independent oversight that you talk about would have informed whoever it is that's responsible for taking the decision? Is it reasonable for me to read that into what you're asking for?
It doesn't actually say that they've got to agree. What it actually says is that they will agree, and if they don't agree, an independent, suitably qualified person will determine. So in my mind, it would just be the independent person determine, and then both of them agree.
So a slightly different way around, I suppose. Okay. Did you want to say any more? No. Okay. Mr. Campbell. Nothing. Council.
Draft condition 36 is a standard condition. This is a process that the council engage with on a regular basis with developers. It is not something that we encounter a concern or issue with. It is a matter of discussion between the council and the relevant developer. It is not simply a case that a number is provided to the council and that is accepted and we move on. So it would be my view that the draft condition 36 provides sufficient protection in this case in terms of securing the financial guarantee requested by Mr. Smith.
So are you saying that within the relevant part of condition and what gets you to the place is that there is some financial oversight, there is some oversight of some kind, yes, that informs whether you would be in a position to agree something? Yes,
it is. There is ongoing discussions between the developer and the council involving financial representatives from the council, and I'm sure in terms of the developer, though, I'm sure the applicant can come in on that. But essentially, the terms of draft condition 36 are used in practice regularly and provide a sufficient level of protection.
So is it fair to say then, in your opinion, that what Mr. Smith has asked for is, in your opinion, what is already there? Or not necessarily in the way that he's asked for it, but at least the principle is, well, you can say.
Yes, I would suggest that I do not think that needs to be reflected in the wording of a condition for a practice that is already in place.
Did you want to say any more before I invite the applicant back?
No, nothing further.
Okay, Ms Howard. I'll let Mr Campbell come in and make his point, and then you'll be able to respond to it. Mr Campbell.
I'll put my finance hat back on again. They've not had any issues between the council and the developer because we've never had to decommission anything yet.
Do you want to respond?
All I would say is the decommissioning bond does require to be in place in advance of construction starting. So whilst we may not have decommissioned anything yet, the practice in terms of ensuring appropriate decommissioning bond being in place is something that has been dealt with between the council and other developers.
Thank you. Mr Whitfield, do you want to say something?
I think just linking the 2 points together, Mr Smith's, one of his concerns, I'm putting words in your mouth, is the quantum. And having never decommissioned, you don't know what the answer is. So hence the independent actuary point. There are sufficient funds. Yeah.
If nothing has been decommissioned, would the independent actuary know? And I think the point being made to me by the council is that there is possibly a process of some degree of independent oversight that provides comfort on what I seem to be comfort on those matters, as Thompson can confirm.
Yes, as matters stand, the process that is in place, the council have to be satisfied that in terms of there being a sufficiency of funds to decommission.
Sorry, just a minute, we're getting a bit noisy in the room. Can we just quieten down so I can hear? Thank you.
So in terms of the wording of the condition, it's sufficient to meet the cost of all decommissioning, restoration and aftercare obligations referred to in condition 34. It would be the view of the council that there is a process in place that allows for that, and the wording of condition 36 would be sufficient.
Thank you. I'll invite the applicant to come back. Obviously, you've heard a bit of the discussion and the rationale behind that. What are your thoughts?
Thank you. Yes, no, I'm in full agreement with Ms Thompson. I would just flag that paragraph 2 of the condition obviously does allow for the possibility of a suitably qualified independent professional being appointed in the event that being required for the council to satisfy itself that the financial guarantee is sufficient. And then in terms of the point raised by Mr Whitfield, I would just point to paragraph 4, which does require the value of the guarantee to be reviewed every 5 years. And also at the point when the detailed decommissioning and restoration plan is approved, and that's at the time of decommissioning.
The condition 36.2 goes a little further. It's the value of the guarantee shall be agreed between the company and the planning authority, or failing agreement, shall be determined on the application of either party by a suitably qualified independent professional. It's there.
Okay, Mr Smith, you've heard other parties' discussion of your contention. What do you say?
All I would say is that from what I have seen decommissioning lots of buildings myself, although not in this country, is that by and large it is underestimated the cost of restoration. And to actually have an independent professional at an early stage determine the cost of dismantling and restitution is absolutely essential to make sure that the council understand the costs that they have to demand from the applicant to take these things down. And I just feel that it is very strange that the authorities, the council, wants to take it on itself to determine what's an acceptable dismantling cost, when in fact there's no need to. You could get it done independently and then put it to the two parties. That's the only point that I'm trying to make, is not anything else, is that the capacity to understand the costs of dismantling. Thank you.
And what do you say in response to the point that was made? I think we were directed to part 4 of the condition, which refers to So the value of the financial guarantee shall be reviewed by agreement between the company and the planning authority, or failing agreement determined on application by either party by a suitably qualified independent professional, not less than every 5 years, and at the time of approval of the detailed decommissioning, restoration and aftercare plan approved under condition 34 that might become a different number depending on where things are. Does that not put in place a review mechanism, and also that last bit about having to be agreed prior to the decommissioning, restoration and aftercare plan? Does that help overcome in some way the concerns that you have?
Absolutely not, because it puts the thing the wrong way round there as well. Instead of saying an independent review of the costing for the dismantling, which would suffice, I'd be very happy, that is the only thing that's necessary, it's actually allowing parties to go into a huddle, come up with a number and call it quits, with actually no reference necessarily to the quantum that is likely to be required to dismantle and get rid of all of the bits and pieces. I mean, we're not just talking about the massive blades, the massive towers, we're talking about the batteries, we're talking about the solar panels, we're talking about restoring everything to site. It's a big project to take apart.
Thank you. Mr. Campbell?
No, I have no comment.
Council?
I'm not sure how much I can helpfully add beyond what I've already said in relation to the council's position here. I would simply state the council is a big machine with a big finance department, and there are many steps and stages that are followed prior to anything of this nature being agreed.
So you're telling me that I'm a town planner myself, so it's not just a town planner that decides, okay, that sounds good to me. There is a process which informs the council.
There is a process that involves relevant expert departments across the council, not simply Mr. Wise deciding that that is the right figure.
I'm sure Mr. Wise would be very good at it, but nevertheless, the point being made is, there's processes that sit behind it. And is it fair to say that those processes are not explained in the condition, or are they?
I'm not sure they're necessarily explained in the condition, but I'm not sure they necessarily need to be explained in the condition.
Okay, I understand your position. Did you want to say any more?
Nothing further.
The applicant then?
Planning authorities must be deemed to behave reasonably. They do behave reasonably. They have the expertise. They don't just sign a bit of paper without a lot of thought. And this industry has been going now for 35 years plus. There is a lot of acquired experience of costings of construction and of decommissioning. We know what we're doing.
Okay. Mr. Smith, okay, you've heard everybody respond to your point.
I've heard it from lots of experts previously that they all know what they're doing until something doesn't go right. Thank you. So in your opinion, there remains a risk without the things that you're asking for? There is definitely a risk to the wider public. And accepting that all things come with risk, there is, in your opinion, is it more that this is an unacceptable risk? I think this comes back to something that we heard earlier, that we don't know what the risk is because it's not put before us. So instead of having a number that should be put before us, we don't have that. And there is a risk only because it is not transparent as to what is going on with regards to the bonds to be posted for decommissioning. I mean, I'm not sure you were necessarily asking for this, but were it the case that the condition was to state an actual financial figure, presumably it will be out of date before it was published. Well, it wouldn't be because the further clause reviews it every 5 years. But that was my second point, which was, and perhaps that does that serve to illustrate the point that there will be a much more mature understanding of the costs that you imply, that you are suggesting might need to be realised at a point closer to the event, and
does the fourth clause provide the mechanism, at least to ensure that that review process is there, and that the final decommissioning and restoration and aftercare plan, which requires prior approval, needs to have the process repeated in terms of the financial guarantee, as I read it. You can tell me if you think I'm wrong. Is that process of doing that not doing and seeking to overcome the issue that you're talking about, recognising that where we are at this date in time, we might not know what it will be in 20, 25 years?
Thank you. The reality is that in 35 years' time, nobody around this table will be looking at what costs are going on in the dismantling. In any entity or entities, be it corporate, be it council, these things, given a wrong base figure, will just be rolled forward and have a percentage added to them for the dismantling that will likely bear no validity compared to the actual costs. And I'm just concerned that 35 years is a long time for companies to actually be still in business these days, and I'm not alluding to anything other than the fact that 35 years is a long time, and we don't know whom is going to take these over and whom is going to be standing ready to take this plant down and restore it.
Okay, thank you, that's clear. Anybody else want to say anything, Mr. Campbell? No? Council? No? I'll let the applicant respond if you want. No? Nothing further? Any more on that? Are we happy to close? Mr. Smith, are you content? Right, okay, thank you all. I'm clear where everybody is on that, so that's been very helpful. Okay, that concludes matter 4. That moves us on to matter 5. Council proposed new condition entitled Enabling Works. This is one of the ones that is subject to the email we were discussing earlier. I'll just read it through for everyone's benefit. So part A, what is the rationale for this proposed condition? B, is it contrary to the advice of the Scottish Government's Energy Consents Unit, ECU, and where would the reporter find this advice? And are there any enabling works that would fall within the terms of what ECU advice intends the condition to cover? Again, I suspect some of this may have been overtaken by events. You were saying earlier you're in a position where the wording that you've proposed in the email is agreed between the applicant and the council. So I'll let the applicant just set out matters.
Thank you. So just to confirm, there are no enabling works proposed here, and it has been agreed between the applicant and the council that such a condition is not necessary.
Sorry, I was distracted there. But would you mind just repeating that, please?
Yeah, so no enabling works are proposed, and on that basis it's agreed between the applicant and the council that a condition is not necessary. And just in terms of the question, just in case it helps, about is it contrary to the advice of the ECU and where would you find that? It's on the model conditions. There's a footnote to the site enabling works condition, which paraphrasing says that it should only be imposed when there's specific site enabling works proposed for that development.
Yes, and for everyone's benefit, I think at the point when you submitted the material to the inquiry, which was before Christmas, I think I'd noted, and I think all parties saw that that ECU document that you've just referred to didn't appear to be amongst stuff. So I think I asked you to submit it, and it's now there. And I think in between times, I think I've found the same thing. So thank you for clarifying that. Did you want to say any more before I invite the council back?
No, thank you.
Okay, Ms Thompson.
Yes, I just simply confirm Ms Howard's position that a condition of this nature is not required now.
Mr Campbell, did you want to say anything? Nothing from Mr Campbell. Mr Smith? Any more? No? Okay, a quick one there. Okay, thank you all for that. That concludes matter 5, which moves us on to matter 6. Draft conditions where a response from the relevant part of Scottish Borders Council is awaited as at 27th of November 2025. So the submitted position on conditions from the applicant and council includes several draft conditions from which comments from the council are, at that time, awaited, and so there is not a finalised position between the two parties. And I've listed those here. Those are Draft Condition 22 Traffic Management Plan, Draft Condition 26, archaeological works. Draft Condition 27, operational noise. Draft Condition 28, BESS, which is battery energy storage system, and solar noise. Part A, have comments now been provided, and if so, where is that information? And B, if not, how will these be addressed going forward? And I've given an example, would it be closing statements? So I'll invite the applicant to just explain matters, and then we'll do what we did before.
Thank you. So just going through them in turn, in terms of draft condition 22 traffic management plan. I'm sorry this wasn't included in my email sent yesterday, but my understanding is that condition is now agreed between the applicant and the council.
Is it agreed as written in the submitted material, or have you made modifications?
There's been a few minor modifications. What I would suggest might be helpful is that after this session, that an updated conditions table is submitted at some point to reflect
The full thing?
Yes. And I can ensure that it's captured in that, I think, so that the updated conditions are all in one place rather than an email here and another email following up with.
I think that probably sounds helpful. Is any objections to that? And as I mentioned before, this particular condition, any modifications like that, you're welcome to comment on those in closing submissions. The applicant will have a chance to comment, because that'll give you time to then look at it. Because it's not before me either, so I haven't seen it yet, but I'm happy for you to submit it in that way. So something is coming on draft condition 22, but that thing that is coming is an agreed position between the two of you,
Yes.
by your understanding. Did you want to go? Do you know what? I think we'll take each one. So did you want to confirm?
Yes, so comments were submitted fairly late in relation to draft condition 22, and I think also draft condition 23 was the same position, in that we were waiting to hear from the same team. They are now with Ms Howard, and by the sounds of it they have agreed. I mean, the amendments are fairly minor in terms of what we are requesting, but I'm sure Ms Howard and I can confirm that position after today, and ensure that is reflected in the updated table of conditions.
And so just to be clear there, you mentioned draft condition 23 as well. So is it your understanding that there are modifications to that?
The council proposed some minor modifications to condition 23, which is abnormal loads, that it simply we're waiting to hear in relation to 22 and 23 from the road planning service team. Those were communicated back to Mrs Howard on Tuesday. So maybe we are quite late in process in terms of sharing that information. But by the sounds of it, I don't think there was anything controversial in that, but nonetheless we'll ensure that is reflected in the updated table.
So what's probably helpful, I think, is if both of you can do your kind of normal just checking process before anything comes to the other parties. Perhaps if you can list in the email that gets circulates the revised full list of condition, the ones where there is change, and that way everyone can be very, very clear. And then they can make sure they make a point of particularly looking at that. We'll stay on 22/23 at the moment. I'll go around. Mr Campbell, did you have anything to say?
On 22 or 26?
23.
23, I'm sorry.
Sorry, can you turn your mic off? Mr Smith.
Nothing, thank you.
Thank you all for that, appreciate it. So back to the applicant then. So do you want to take us through draft condition 26?
Yes, draft condition 26, archaeological works. There's no update on that yet. I understand from Ms Thompson that some further input from the council is coming imminently. So that's another one that we could perhaps discuss, tomorrow or over the next couple of days, and incorporate that into the revised table.
Certainly, if there's a prospect of it being in the revised table, it's worth waiting till it's done, and then we can have everything rather than several versions. I think that would be less confusing. Sorry, have you said everything you want to say on that?
No, that was everything. Thank you.
Sorry, I pressed the wrong button there. I thought I was on Heidi High for a minute. Right, okay.
Yes, Ms Howard accurately reflects the position. Both Mr Wise and I have some input from archaeology officers sitting in our inbox. We just haven't had the opportunity to review that fully in the course of the last couple of days. I would intend to communicate that to Ms Howard either later today or tomorrow morning.
Okay, thank you for that clarity. Mr Campbell, anything? Mr Smith? Nothing. Thanks very much. So, Ms Howard, you can take these individually or together, depending on what you feel necessary. 27 and possibly on its 28, or what, together or apart?
Dealing with them together. As Mr. Trinick mentioned at the opening of the session this morning, we are moving towards, I think, agreement on the conditions. We've got the council's input. It's been reviewed by the applicant's advisor. We just need to consider those comments and come back. But we are moving towards the direction of agreement.
And to quote Mr. Trinick's words from yesterday, you are embracing Mr. Campbell in this discussion. Is that correct? I'm sorry, did I interrupt you? Was that the point you were going to make? Mr. Campbell?
When agreement is reached between the council and the applicant, obviously I'll see that condition rather than comment on it today, because my view is an outlier from the rest of the people around the table. I'll do it in my closing submission.
Understood. Sorry, I'm not...
to both of those conditions.
Are
you happy with that?
Yeah, I'd made that remark at the start, particularly as there's likely to be modifications to it. So yeah, you're not in a position yet to know what the final agreed position between them is, or whether you agree on it or not. So yes, closing submissions is fine. I'm sorry, I skipped to the council there. Do you want to come?
That's no problem. I think it's a position that agreement may be reached. There's no guarantee that we're going to reach agreement in relation to this condition, and if there are matters that have to be addressed, that could be addressed in closing submissions, as Mr. Trinick stated earlier today.
Thank you. I'll come back past Mr. Campbell. I suspect there's nothing that's just been said that would change what you said before. Did you want to say any more? No? No, fine. Mr. Smith. Okay. Any more matters? Did you want to say anything by way of close on that at all? If there's no more, then that brings us to the end of the hearing on draft conditions. So thank you very much to everybody for their input on that. That also brings us to the close of this public inquiry. So there's some things I need to say before we formally close. So all hearing sessions are now concluded. I will shortly go through the formal process, as I say, of closing. Before I do that, there's various housekeeping things that I need to run through. In a moment, I'll ask parties if they've any points we need to make before I close. So while you're having a think about that, I'll just run over the closing statements and summaries of case. It was agreed yesterday at Mr. Campbell's request that closing statements and submissions and closing statements and summaries of case for the council and other objecting parties would be submitted a week later than had previously been agreed. So that is within 21 days of the close of the inquiry. So that would be by Friday the 6th of February. And then the applicant will be invited to submit its closing statement and summary of case 14 days after that, so by the end of Friday 20th of February 2026. We discussed the principle of that yesterday. Are parties content with that? Does that sound? Yep, no issues. Okay, so those dates are what they are. After those have been received, I will be writing up my report for Scottish ministers. I cannot tell you of the exact timescales for me concluding that. Once I have completed my report and its recommendations, those will be passed to Scottish ministers. Scottish ministers will then determine the application. Those who submitted representations, and of course the applicant and other parties, will be advised of Scottish ministers' decision when Scottish ministers have made that decision. I'm sorry, that's not something that's within my control at all, so I cannot tell you exactly when that will be, but that is the process. I need to say some important thank yous. Firstly, thank you to all the participants for your time. Some of them are not here today, so I'll be grateful to pass on my thanks. Thank you for your time and efforts to assist me in understanding the matters in question. I'm extremely grateful for that. Thank you to the venue and the town of Duns for hosting us this week. We've enjoyed very much being here. Thank you to Christine Brown, the DPA case officer, and to Craig, who was here on Monday, and David and Connor for running our webcasting and internet services. And thank you to all of you who've taken the time to come and listen and participate and be with us, whether you're watching online or whether you've been here in person. Are there any other matters for me before I formally close the inquiry? Mr. Smith, do you have anything? No. Mr. Campbell.
I'm sure my friends would agree with me that we should thank you for a well-conducted, very expeditious inquiry, by and large, with a good humour. And it's very gratifying to get through all this business in what really was 2.5 days of evidence. Mr. Trinick and I were recalling that the first time we met in a public inquiry, it took 6 weeks. And we were so tired that we took a week off in the middle. So thank you very much.
Very kind, yes. 6 weeks would be a prospect, wouldn't it? Goodness me. Thank you. The council? And the applicant? No. Very good. Thank you all, and wishing everybody a safe onward journey. I now formally close this public inquiry. Good afternoon.